Hey folks, in this video, we're going to talk about why he said, she said cases are super difficult in Virginia claims and Virginia car accident claims. And what I mean by he said, she said cases are situations where uh, we're trying to demonstrate who's at fault for the accident. And let's say you are claiming that you were injured due to somebody else's fault in a car crash, and they're claiming it wasn't my fault, it was your fault. So he said, she said is really not simply just he said, she said. It could be she said, or he said, and every other combination. But really, the point is situations where you have a version of events and the other person has a different version of events. And when it comes to Virginia car accident cases, there's two issues that we've always got to prove and consider in a car accident case. First is liability, and second is damages. Liability is who's at fault for the accident, and damages is what flows from the accident. But if you can't prove liability, damages is irrelevant, because if you can't prove the other party is liable, you get nothing. So under Virginia law, Virginia applies something called contributory negligence. What is contributory negligence? Contributory negligence is a concept that says essentially, if one party is 99% at fault for an accident and the other party is 1% at fault, the party that's 1% at fault is barred from recovery. Essentially, both parties are barred from recovery because they're both at fault. That means that if you are a plaintiff, you are an injured victim in an accident, and a jury finds that you're just 1% at fault, you lose. You're barred from recovery. If a judge or a jury finds that you contributed at all to the accident, they can't award you money, no matter how badly injured you are. I'm talking about fractures. I'm talking about surgery. I'm talking about death. This rule is unforgiving. I think we're one of 3 states in the union that apply contributory negligence, but it's super, super important. And so that's the reason when it comes to he said, she said cases, it's really hard, because not only does the jury have to determine who's at fault for the accident, they've not only got to find that, who they think's more at fault, they have to find that you as a plaintiff are barred, are not at fault whatsoever. So oftentimes when it comes to he said, she said cases, without an objective witness or objective evidence, it's simply hard for judges and juries to decide. It's simply hard for them to find in a plaintiff's favor if it's a situation where the plaintiff's claiming one thing, but the defendant is claiming another. Without some outside or way to tip the scales, oftentimes judges and juries are simply just going to say, look, we have to find against the plaintiff because we just don't have the evidence. And I can tell you, having tried many of these cases, because earlier on in my career, I said, well, let's see, maybe we can just have my client sound more believable. And we put on many good cases where I think my client was completely credible. But a jury has been left with, well, the other person just saying that, and I don't really know either one of them. And look, they may get to know you for a couple hours, but on the liability issue particularly, it's going to be a very short segment of time where a jury is not going to have the ability to really demonstrate or decide without an objective witness or other objective evidence in favor of you from a plaintiff standpoint. Now, I want to be clear. I'm not saying that he said, she said case is simply unwinnable for a plaintiff, but I'm emphasizing that they are very, very difficult. And if you have one of these situations without any objective witness or objective evidence, you've got a tall order. You've got a very steep hill to climb. And I can tell you, at least in my practice, unless I've got some unusual reason, I'm likely not going to accept a he said, she said situation, just because it's so difficult. So with that being said, if an accident happens, here's a few suggestions I've got. Make sure that you get witness information if you're physically able to. Let's say you're involved in a car accident. You get out of your car and there's witnesses around. Talk to the witnesses. Get their information, phone numbers, email addresses to the extent you can, addresses. If law enforcement is the only one that did that investigation, and follow up with them and see if the defendant was charged. If they were charged with like failure to yield or something like that, and then that case goes well in the traffic court, while it doesn't mean that you automatically win, it can be super helpful. Dash cam videos are super useful. So I keep on intending to put a dash cam on my car in case I'm in an accident, because I know that that objective evidence will be super helpful. If you happen to have a dash cam video, I can tell you in some of my cases, not a lot of them, I've been lucky to be able to determine dash cam videos later on. Somebody either sent me a dash cam video because they witnessed the accident, or other types of videos. Let's say you're in an intersection where there's businesses. Definitely make the effort, if law enforcement hasn't already done that, to go seek out whether or not there's surveillance videos. I've had cases where they're at the intersection of a coffee shop, and it just happened to be that the coffee shop had a camera that was pointed at the intersection and captured it. So this is the kind of evidence, while it sounds like it might be a long shot, if you've got a he said, she said case, you're going to need, because I can't tell you again how many cases I've dealt with where earlier on in my career, I would take more risk because it was interesting, and it still is interesting, but having not have seen a lot of success, and I think we've done a good job in presenting those cases, the clients are usually happy with our presentation. But at the end of the day, if the jury is left with contributory negligence rules, as well as a way not to sort it out, oftentimes you're going to have a very, very difficult case. So I don't mean to do this video to scare you. If you've got an attorney, make sure to ask them questions about it. But at the end of the day, I think it's important that you're well aware, and people watching this are well aware how difficult Virginia law is. So wish you guys the best. Let me actually throw up my information real quick. Here's my website, phone number, email address. Feel free to reach out. I'd also recommend subscribing to the YouTube channel, because that would be, and you can comment below, and we're trying to increase our reach. But hopefully this is useful. Wish you guys the best. Until next time, stay safe.